Right now. And we are live, Mr. Chair.
Okay, great. Thank you, Sam, Mr. Clerk, for that. And we are going to call the meeting of the Data Privacy Working Group to order. It's 11:05 on November 2nd. I'd like to start by asking the co-chairs. I see both Representative Gilchrist and Representative John Michael Parker are here. If they have anything that they would like to say.
Just welcome everyone and looking forward to learning more today. Thank you.
Thank you.
Thanks, Senator. Echo that. Happy to be here and looking forward to spending some time with you. I'll keep my camera off because I'm feeling a little under the weather here. Perfect timing with an election a week away. So, but thanks all for joining. Thanks for organizing this, James.
Thank you. And thank you to Representative Parker and Representative Gilchrist for being here. He does point out a good point that we have an election less than a week away. And I want to thank them for participating in the working group as I try to put together another working group. And I reached out to some other legislators and they said, you're insane if you want to do this before the election. So for the people who have been with this for a few years, you already knew I was insane anyway. So, but I want to say I really appreciate you guys making the time. I know how valuable your time is. Unfortunately, we had sent out an initial agenda for the meeting, and due to a family issue, Kate, and I apologize for any names throughout the meeting that I pronounce incorrectly, but Kate Vilak from Washington, D.C., the D.C.'s Office of the Attorney General, will be unable to present today, but instead we have Stephen Stitch, who is a clinical lecturer and local journalism fellow at Yale, who is going to present, do the first presentation on algorithmic accountability, the need for a new approach to transparency and accountability when government functions are performed by algorithms. And so that is another area. And I think one of the things when we look at expanding these, looking at regulating the AI and algorithmic decision making, I'm realizing so many of the things we're looking at were areas that were specifically excluded from our Data Privacy Act. So we're really looking at going into new areas here. But Professor Stitch, if you would take over, and Sam, if you can make sure he's able to share his screen. And then the other thing is at the end of the meeting, we will do our best to get all of the materials together and disseminate them to everyone. And as far as if you have questions for the presentation, members of the working group, if you would like to, raise your hand and then I'll acknowledge you. If other people have questions, if you can just, actually, I don't know if we have the chat function on here, but so for this time, we'll just leave the questions and the discussion to the members of the working group. Thank you.
Thanks very much for the opportunity to step in and talk about this issue. So I'm going to discuss algorithmic accountability, which is an issue that's been gaining a lot of attention in recent years from lawmakers, scholars, and advocacy groups. What I'm going to discuss today grows out of a report that my clinic authored in January of this year, which I believe was circulated in advance. I'm happy to share it with anyone else who might be interested, although there have been developments since we drafted it that I'm also going to discuss today. So I want to do three things this morning. So first, I'm going to spend a few minutes just describing the algorithmic accountability issue. Second, I'll summarize the investigation that my clinic undertook and is still undertaking to diagnose algorithmic accountability in Connecticut and explain our conclusion that there's substantial room for improvement. And third, I will outline some suggestions for possible ways to improve algorithmic accountability in the state. So the algorithmic accountability issue, which I'll define in a moment, is really the natural outgrowth of an entirely benign and often laudatory inclination on the part of public officials, which is to incorporate cutting-edge technology into their government decision-making. So for example, some technologies process just far more efficiently than humans, which frees up resources for people to use in other important matters. Take processing applications for public benefits. That can be a laborious task for people, but computers can often do it in a fraction of the time. Why not let the computer handle it? Other technologies can draw connections among patterns that humans just don't have the brain power to find. So imagine an agency could use a computer algorithm to determine what combinations of qualities make for the most successful civil servants, and then incorporate those findings into its hiring decisions by, for example, screening resumes. Seems like who wouldn't want the agency to hire the best people? Still, other texts promise objectivity in areas traditionally subject to bias. For instance, a lot's been written about racial bias in parole decisions. And try as one might, it's often impossible to eliminate unconscious bias even among the most well-meaning parole officials. But computers don't see color, so maybe using them solves the problem. The issue of algorithmic accountability is this. All these functions, determining benefit eligibility, hiring employees, deciding who gets out of prison, much more, they're government functions. And as government functions, the public has the right and the responsibility to oversee them. But entrusting core government functions to algorithms has the potential to hinder that oversight and prevent the public from holding the agencies accountable. So the question is really how to empower agencies to leverage the benefits of technology while also empowering the public to exercise its crucial oversight functions. The oversight functions are particularly crucial due to a couple of problems algorithms might exhibit that are often difficult to detect. And I'm going to focus on two today. Possible ineffectiveness and possible bias. So ineffectiveness just means that the algorithm doesn't perform as it was intended to due to a flawed design, bug, infiltration of malware, any other number of problems. Bias means that the algorithm is designed in a way that reinforces or perhaps exacerbates existing social prejudices. This problem results from the algorithm being developed using data that itself stems from bias. Saying often goes garbage in, garbage out. So I'll illustrate these issues using the same examples I gave earlier of algorithms in public decision-making, benefits, employments, and parole. Each is drawn from a real-world case of algorithms gone wrong somewhere in the country, and then I'm going to focus in a moment on Connecticut. So the benefits example comes from Indiana, where a young woman with ovarian cancer was denied several types of benefits after an algorithm determined that she no longer qualified for them. She lost her meds, lost her food stamps, and lost her transport to medical appointments. She appealed the denial of benefits that the algorithm had made, and she won that appeal. But by the time she won the appeal, she'd passed away. This is an example of just a simply ineffective algorithm, one that went wrong and unfortunately led to tragic consequences. The employment example comes from Amazon. So it's a private company, but you can imagine the same happening in the public sphere. Amazon uses artificial intelligence to identify traits in successful employees. But the traits that are associated with success were simply those of the people who got far in the company. And so if that success resulted from bias, then so did the traits the computer picked up on. And sure enough, the algorithm picked out fewer women among the stack of resumes that it was reviewing. So this is one type of bias. The parole example shows another bias in another way, in a way that's perhaps even more entrenched. So several states have adopted algorithmic tools in parole decision-making specifically to prevent unconscious bias from infiltrating a parole's release decisions. But doing so might inject bias in a different way. So these algorithms that they use predict an offender's risk of reoffending, and they make those predictions using real-world data about who's been found to reoffend. So it probably wouldn't surprise anyone that that data is infected by its own form of racial bias. African Americans are more likely to get ensnared in the criminal justice system than those of other races. And it's for precisely this reason that statistical analyses of one of the most often used parole risk assessment tools has found it to be biased against African Americans as compared to white individuals. So all this to say is the more powerful the algorithm, the greater its potential for unintended negative consequences. Both the public and the agencies that use the algorithms need to monitor them closely. And that's where our investigation comes in. So nearly 2 years ago, we set out to understand algorithmic accountability in Connecticut. Since then, 4 generations of my students at Yale Law School have worked on answering essentially the following 4 questions. The first question is, how have Connecticut agencies used algorithms and what effect have they had on Connecticut residents? The second is, how do these agencies monitor whether their algorithms make inaccurate predictions or recommend biased decisions? The third question is, how transparent are the agencies about these issues? And the fourth question, which is the third topic of what I'm going to discuss today, is what are some possible solutions for the problems that the rest of the report identifies? So we first conducted some research into which agencies used algorithms at all, and that proved surprisingly difficult. There's no database or repository or really any other systematic way to find out which agencies are using algorithms. We had to do a lot of our own searching, which really just amounted to looking at which agencies exist, Googling them, and seeing if there were stories about them using algorithms. Took a lot of work. We didn't really attempt to compile anything definitive. Instead, we sort of we decided to look further into some specific agencies that had algorithms that were used in particular areas. So this essentially means that in the current environment, it's pretty hard to answer like the most fundamental question of how Connecticut agencies use algorithms and how its residents are affected by them. So after this initial research, we identified, as I mentioned, 3 agencies that use algorithms in pretty important areas. And we filed FOI, Freedom of Information requests, with these agencies to learn more about their use of the algorithms. The requests sought pretty basic information about the algorithm, such as how it was developed or procured by the agency, its internal logic and source code, how the agencies trained staff to use them, and how humans were involved in the decision-making they recommend, and how the agency assessed the algorithms for things like error rates and the potential for disparate impact. By filing the requests, we hope to learn how the agencies monitor the algorithms they use and how much public oversight they permit. So this is the monitoring and transparency questions. We learned quite a bit from each agency, and I'll just go through them. So the first was the Department of Administrative Services. And we learned through our research that this agency uses an algorithm to screen applicants for jobs with the state. So due to experiences like Amazon, we figured this would be an important agency to FOIA. Unfortunately, despite filing the request over a year and a half ago now, April of 2021, we still haven't gotten any records from it. So in our view, scores low on transparency and on monitoring, can't really assess it because we didn't get any documents. The second agency was the Department of Children and Families. We FOIA'd this agency for an algorithm that it uses to predict which children that are already known to it, so already in the system, were at further risk of life-threatening episodes. This algorithm was developed by a private company that licensed the algorithm in other states. And at least one of those states, Illinois, had abandoned it because it was ineffective. So we chose this algorithm because it's a really important issue, and another state had apparently concluded that it wasn't very good. So to DCF's credit, it was transparent. So we filed our FOI request, and it produced everything that it had that we asked for. So it didn't withhold any documents. Because it fully granted the request and produced everything that we asked for, that it said that it had, this allowed us to pretty well assess how it was monitoring the algorithm. And here, unfortunately, it did quite poorly. So we were able to determine that the agency used the algorithm for 3 years and appears to have discontinued it due to resource constraints. In response to our 12-item request, it produced under 200 pages of responsive records, most or many of which consisted of training materials by the vendor that sort of also seemed to be serving as marketing materials. We got a contract between the agency and the vendor, but not any request for proposal. And the terms of the contract and the absence of a request for proposal, which we had requested, suggests that the agency didn't require the algorithm through normal procurement channels, which sort of is another way that oversight is a little impeded. That would be one way that you might find out whether agencies are using algorithms. DCF produced only cursory information about the algorithm's internal logic. So we know some of the factors the algorithm considered to identify children's risk levels, but we didn't learn how the factors were combined. The agency apparently didn't have that information. Importantly, DCF also did not produce any of the requested assessments for effectiveness or bias, which we had specifically asked for. In fact, it produced an email from one of its officials noting that it had never performed a formal evaluation of the algorithm for effectiveness in the 3 years that the agency had it. So this suggests that these evaluations weren't happening. And we think this is a quite significant problem. The algorithm is part of a really important process, determining if children are abused or neglected. And it has the potential for very serious consequences if it doesn't work properly. Either the algorithm misses a child in need and that child continues to suffer, or it identifies a false positive and kind of interferes needlessly with the family. And it does so in an area where the potential for bias has been well documented in other states, particularly biased against the poor and bias along racial lines. So our view is that DCF should have done far more than it did to monitor the algorithm. The final agency was the Department of Education. There we FOIA'd a lottery algorithm that it used to assign children to schools as part of a settlement in Sheff versus O'Neill, which is the longstanding racial discrimination case in the Hartford area. So this algorithm was developed in part by a private company, but we learned that the SDE had some degree of impact in sort of determining how it worked. So the SDE scores in the middle for transparency, but in our view, not good. And the monitoring, again, it's a little hard to assess how well it monitored the algorithm given what it produced to us. So like DCF, it produced the contract with the vendor and it produced some procurement records, and the procurement of this algorithm appears to have been more standard. In responding to the request, it listed a few factors that are considered when making school assignment decisions, but not all the factors and not how they combined. Again, so we don't really know how the algorithm assigns children to schools, which is what it's designed to do. It denied substantial parts of the request and withheld a lot of the records. This includes most information about the inner logic of the algorithm, including how the factors combine and what they are. It also withheld all the documents analyzing the algorithm's error rates, effectiveness, risks, limitations, and potential for disparate impact. The fact that the agency withheld this information suggests that it was performing some evaluation, but because we didn't see the documents, we couldn't really assess the quality of that evaluation. The SDE based all of its denials on one ground, which was that the material, including the disparate impact analyses actually, were exempt trade secrets, and presumably the trade secrets of the private company from which it bought the algorithm. So in other words, it's shielding information that has incredible value to the public by claiming that it would negatively impact the bottom line of a private company in an area that's a core government function of assigning children to schools. And we've appealed this decision to the Freedom of Information Commission, and those proceedings are ongoing. So we'll likely have further updates later in the year once the commission later next year, I'm sorry, once the commission reaches its decision. So to conclude about our investigation, we essentially determined that by and large, agencies are not really effectively monitoring their algorithms, at least to the extent that we could evaluate that. And they're not really enabling the public to do that either. And this raises substantial risks that the algorithms affect Connecticut residents in ways that no one understands and that could result in sort of unintended negative consequences that no one really appreciates, including the agencies. And that brings me to the third and final topic that I want to briefly discuss here, which is what can we do about this? I think we can divide the solutions here into two broad buckets. The first focuses on agencies' oversight of algorithms, and the other focuses on transparency. So the first is mandatory algorithmic assessments. So the idea here is to require agencies to subject their algorithms to assessments for factors like ineffectiveness and bias. And there's a few different options or axes that these assessments might take. So the first revolves around the question of when is the agency, or when are they supposed to be performed? This could be before the algorithm's used or periodically while it's being used. Another question is who performs them. The agency could do it itself, could be done by outside auditors, academics, other credentialed individuals. And another question is, what is the agency supposed to do once it's done its assessment and once it reaches its particular conclusions? There's a lot of proposals about this, and I'm not going to go through all of them, but I want to just briefly mention one, which is used in actually the Canadian Directive on Automated Decision Making. It's a pretty comprehensive process, which is why I'm going to focus on it. So that directive requires that agencies perform an assessment before adopting an algorithm. The assessment's the same for all agencies, and it's developed by a particular agency in Canada. A bunch of questions are asked, like, is this an area where particular risks are involved? There could be, medical privacy issues, that kind of thing. What sort of data is being used? What's the subject matter? What are we going to use the algorithm for? Once that assessment is done, the algorithm is scored on a risk scale, and depending on how highly it scores, different interventions are required. So, for example, algorithms that are determined to be more risky have to be subject to approval by people within the agency that are more senior. So the top level maybe has to be in the Canadian parlance approved by like a deputy minister or the minister. Riskier algorithms have to have staff training that is more rigorous. They also have to be reviewed by more people and or individuals with higher qualifications. So maybe like a professor. And a fourth dimension is human involvement in decisions made by algorithms. So sometimes, the lower risk algorithms, the algorithm can sort of make the decision without any direct human involvement, although it has to be subject to appeal. Higher risk algorithms can only recommend decisions, and humans actually have to make them. So that's one bucket, mandatory algorithmic assessments. The other bucket is increased transparency. And there's really two issues here. One is just the public knowing which agencies use algorithms and for what general purposes. The solution to this problem could be to require agencies to affirmatively disclose, for instance, what algorithms they use and roughly for what purpose. They could also be required to disclose their risk assessments. And the second issue is really sort of posed by FOI laws. So a common problem that people run into when they try to learn about algorithms, which our Department of Education example illustrates, arises from agencies using algorithms developed by private companies to carry out core public functions. There's not anything necessarily wrong with that, but in practice, it leads agencies to prevent public oversight by invoking the private companies' trade secret protections. So one solution to that is to sort of lessen those protections in various ways, and I want to mention a couple. One is to enact legislation that specifies that before an agency can procure an algorithm, the company from which it procures it has to waive trade secret protection. Usually, this approach really, I think, works best when it's cabined to particular areas that are particularly sensitive. Idaho has already done this, actually. It requires that whenever an agency wants to procure an algorithm for bail determinations, it has to get the company to waive its trade secrets. Another approach is to simply specify that trade secret protections can be overcome by sufficiently strong public interest and oversight. So legislators in other jurisdictions like Idaho, for example, have proposed various solutions to this. There's also growing academic literature that I'm not going to get into it any more than I already have. And the solutions that I've outlined are illustrative and not necessarily comprehensive. But the take-home point is that while agencies should be free to adapt to the fast pace of technological development, they shouldn't do so by leaving accountability, sort of leaving it behind. So that's all I've got, and I'm happy to answer any questions.
Great. Thank you very much. Let me see if anyone has raised their hands for questions. Please. I don't see anyone who has raised their hands yet. So what I'll do is I'll ask, I do see someone. We'll start with David McGuire, and then I will have some questions after that. Okay, David.
Thank you, Senator. Thank you, Stephen, for the presentation. Question for you on the mandatory algorithmic assessments. Are those assessments that you envision being used as the algorithm is in place, or is that kind of a validation or testing before it's rolled out, ideally?
In the ideal situation, it would be both. the agency would probably do its own assessment before using the algorithm. And then while it's using the algorithm, it would be subject to periodic audits, either by itself or by outside individuals, or ideally both. And if you were to implement something like the Canadian system, how often those audits take place or who has to do them could be determined by the level of risk that the algorithm poses.
Really quick follow-up on the Canadian model. Do they have some public report out of the outcome of that testing? So some of that's public. I mean, some of it can't be public for various reasons. You could imagine like a law enforcement agency can't say too much about some algorithms that it uses because it might kind of prevent the techniques from being effective, but there is some method of that being published, yes. And that's something that I would recommend. Thank you so much.
Thank you.
Great, thanks, David. Antoinette Webster.
Thank you, Senator. Stephen, thank you for your presentation. I had a question. Can you speak to what kind of expertise would be sufficient for an agency to create the algorithm?
So, I mean, I think that question really depends on what the algorithm is meant to do. So, you could imagine two types of resume sorting algorithms, for example. One is really the sort of complex machine learning algorithm that uses artificial intelligence that I discussed earlier with Amazon, right? And that would require a lot of sophistication. You could also imagine a much more simple algorithm that sort of picks out discrete qualities. And that algorithm is used, part of what it does is it determines what qualities are sort of good in an employee and then tries to find them on resumes. You could imagine a much simpler one where the person who designs the algorithm themselves specifies the qualities of a successful candidate. So maybe they need to have like an undergraduate degree to do a particular job and plugs that in. And that's a much simpler thing to do because it doesn't require designing an artificial intelligence system. So I think the answer is that it really depends. I think the algorithms that are sort of most important for the public to be able to oversee are those that are more complicated, partly because this issue of biased data causing biased results is largely an outgrowth of artificial intelligence algorithms. And that's one issue that I think is very important for the public to be able to assess. So yeah, but I mean, to directly answer your question, it really depends on what the algorithm is trying to do and how complicated the agency wants it to be.
And as a follow-up to that,
Did you just
I'm sorry. As a follow-up to that, Stephen, was it your experience in this investigation that companies who maybe had the expertise to generate the algorithm to meet the agency's needs were expertise in that, and that really would be difficult to snap out of a trade secret definition? Like how did you learn a little bit about that with the state that it was Idaho, right? That was able to allow that to be waived. I just imagine that there's a level of expertise that would be required to create these algorithms, and potentially vendors are using a certain form to generate them, and then that becomes their product. So just curious on your take on that.
Yeah, so I think there's a couple of questions embedded in there. So in the Idaho case, we didn't go through all of the sort of procurements of Idaho algorithms that were done after this law was enacted. It was enacted 2 or 3 years ago, I think. But it's my understanding that sort of the requirement to waive the trade secret protection didn't actually deter the procurement of those bail algorithms. That's not something that I've studied extensively, but that is the impression that we got from sort of our initial research into that. And one of the reasons for why this might be is that often these algorithms can be bespoke for a particular agency. And that's actually what I think is going on with the SDE algorithm, the Department of Education School Lottery algorithm, because what little we know about this, and we really didn't get that much information about it, is that SDE itself has some degree of input into the factors that go into assigning students to schools. And so to the extent that the algorithm is bespoke for a particular state, that would seem to substantially reduce the risk to a company of exposing its proprietary information, because there is only one version of this product, and it's for the state in question.
Thank you.
Thanks.
Thank you. So I'm very glad we have someone from DAS who's part of the working group because and actually I'm glad, I was looking forward to the Washington DC presentation, but I am glad that we were able to have you present, Stephen, because one of the issues I thought was, I think it's always best to lead by example. So when we were going to, my thoughts on where the legislation may end up would be starting with the government, right, and regulating what we do. So I guess I have some questions around that. One of my initial thoughts was looking at requiring impact assessments on any software or any algorithms that we went out to purchase through RFP. Now, I guess in the Canadian model, you say there are different rules on how the algorithms are used based on lower risk or higher risk. And is that, how is that determined? Was that put in, and I guess it was an order, not necessarily legislation. So is there an agency that's tasked with identifying the high risk versus low risk processes, or is there just a definition that would be used?
So my understanding is that an agency generated the risk assessment, or it generated the sort of form for the impact assessments.
Okay.
And then the agency that then uses the algorithm sort of analyzes its algorithm using that form. And that sort of spits out a risk level at the end.
Okay. Now, are you aware, so I guess there is a model of an impact assessment that Canada has generated. So because I know, like, looking at some of the legislation, and we're going to have other presenters later on the ADPPA, but looking through the DC legislation, there are requirements for impact assessments, or it could be different terminology, but something along those lines. So I guess it would be good to know if there is a model there. So, and then also thank you for doing the work, because another place that someone had suggested we started was, I'm not sure which state, but somewhere had required all of the agencies to go through and identify where they were using. They wanted to start with where they were using the AI. So thank you for starting to do that research for us before we look at potentially, I guess, mandating that or trying to find out where AI is being used and the algorithm decision making is being used. Are there any other questions? If not, thank you very much, and hopefully, as we move through the process and come up with actual proposed legislation, I would hope that you would be willing to stay in touch, and then when we do have something, hopefully you'll be able to testify when we get a bill.
Absolutely, and thanks so much for the opportunity to talk to you all this morning.
Thank you. All right, so next on the agenda is, let me see if it is Professor Kaminsky from Colorado School of Law on?
Yes.
Okay, great. Thank you so much. So the next presentation is Margot Kaminsky from the Colorado School of Law, an overview of AI risk regulation.
Thank you so much. So I also, as I'm getting the slideshow up and running, want to state as a point of personal pride that I was a co-founder of the Mafia Clinic that Stephen now helps to run. So it's wonderful to see them continuing to do such great work and now intersecting with the policy work I'm now focusing on. So I'm going to be talking today about artificial intelligence and risk regulation. We just had a bit of a preview here in the discussion of impact assessments. And I'm hoping to offer to you all somewhat of a menu to let you know what different kinds of risk regulation are out there. Stephen already really helpfully laid out the problems that risk regulation is trying to get at, so I may skim through that part of the presentation in the interest of time. And I'm also hoping to discuss a little bit the limitations of risk regulation as an approach. So we're somewhat jumping ahead here, right? We're saying do impact assessments, and if you end up doing impact assessments, here are the limits of the impact assessment approach as policy decision. So in the talk, I'm going to give 3 parts. The first part, I'm going to talk only very briefly about the harms produced by AI systems, since we already had an overview, and identify a few more of the common kinds of problems that cause these harms. These have led to calls for, and in some cases, actual enactment of omnibus baseline artificial intelligence law. So there is such a thing as AI law. In the second part, I will talk about, I'll sort of zoom out and do the law professor thing. I'll talk about how these regulations are a particular type of regulatory vehicle, which is risk regulation. Regulators are construing harms as risks, right? They're deciding that they're going to look at this systemically. They're going to look at it, the problem ex ante as opposed to ex post. And in a lot of ways that makes sense as an approach to AI harms. However, using risk regulation to govern artificial intelligence actually brings with it policy baggage. So we know from looking at the literature and policy critiques of the use of risk regulation in, say, toxic chemical regulation or environmental regulation, that there are limits to what risk regulation can effectively do. So again, in this part, I'll be fairly brief since we already heard about this. I want to talk just briefly about how the law defines artificial intelligence. So as we heard, AI is a computer program, right? Typically, when people talk about artificial intelligence, they're really referring to a subset of computer programs, which is machine learning. However, the legislative definitions we're seeing emerge around artificial intelligence are far broader than just coverage of machine learning. The EU AI Act, or the draft EU AI Act, defines it effectively as software, which includes machine learning approaches, also includes logic and knowledge-based approaches, and even includes statistical approaches, which are computer programs we've had in existence for decades. So the real hook for artificial intelligence law is less the definition of the technology and more how that technology is being used and what effects it has on people. The 2019 proposed Federal Algorithmic Accountability Act defined AI as a computational process that makes a decision that impacts consumers. And when we're talking impact, we're talking significant impact. So if you think about the due process framing, it's the sort of impact that actually would trigger, say, due process rights were this performed by a government entity. As we heard, artificial intelligence systems are already widely in use, including in software that we've probably each interacted with today. And they cause significant harms ranging from physical to dignitary. There's a 2018 story of an Uber self-driving car that killed a pedestrian. We have widespread use of AI tools in the private sector for screening and ranking job candidates. And in the health sector, again, widespread use of artificially intelligent algorithms in the context of risk prediction, where a story coming out of Massachusetts shows an AI, and this was covered in Science, shows an AI that was incorrectly designating Black patients as lower risk and giving them poorer healthcare, because the AI, it turned out, was actually trying to predict what the cost of healthcare would be for different patients, as opposed to predicting the real health risks to those patients, which is a target variable problem I'll talk about in a moment. And we see AI in use in many other places, ranging from targeted advertising to test software to predictions of how students will perform in school. So on the one hand, the legal environment for each of these is very different, right? We're talking the range of car regulation and tort law all the way to data privacy law. On the other hand, just as in data protection or data privacy, the problems seem to emerge from a common set of patterns that are specific to the technologies. As Stephen discussed, we have the garbage in, garbage out problem, where the use of a machine learning algorithm replicates the bias existing in a data set. We have issues around target variables, meaning the type of thing that the algorithm is trying to predict. So these problems range from having a system, as I just described with the healthcare algorithm, that's not actually aiming at what you think it's aiming at, right? So you have a health algorithm, public health algorithm, that purports to find people who need additional healthcare, but in fact identifies people who tend to spend more money on healthcare, which is not the same thing. Or you have a bail algorithm that, instead of telling you who is likely to actually reoffend and be convicted, tells you who is likely to be rearrested, which is a different question involving many different types of factors in terms of how that data gets produced and gets into the system and what bias it brings along with it. Another problem with target variables is that in trying to create these proxies or trying to arrive at what is the machine trying to solve, it may accidentally create proxies for protected classes. So for example, in the employment context, a machine learning algorithm might determine that somebody's zip code is in fact really predictive of how good of an employee they're going to be and whether they show up on time. And we find out that the zip code is also itself determinative of what racial and ethnic background the applicant is coming from. I wanted to highlight this because I have a separate paper on this, on humans in the loop. So Stephen mentioned one of the solutions governments have been arriving at is to put a human into the decision-making process, but it actually turns out to be way more complicated than that. Human machine systems are complex systems with known points of failure and particular design principles that should be used when you're placing a human in the loop. And often algorithmic decision-making involves a human who is not well-trained or otherwise not empowered to intervene in any meaningful way. And then finally, and these are not the only problems, this is just to name a few common ones. We have the problem of abstraction, where an algorithm that is designed for use in one context, for example, an algorithm that's designed to predict which prisoners are most likely to benefit from rehabilitation in prison, might then be used in a different context, for example, to try to predict reoffense. And you have all sorts of problems that emerge from this, both in terms of the users, their training, how confident the programmers might be in the output of the algorithm might not be communicated to the users of the algorithm. And you may have sort of built-in assumptions from the original context that aren't communicated to the user or the agency using the algorithm. So now we turn to this approach of risk regulation. The consequences of AI systems, as in most consequences in law, can either be characterized as harms or they can be characterized as risks. What do I mean by this? Well, coming back to that Uber car crash in 2018, one way of looking at what happened is to say that in the immediate circle of events, the car killed a person, right? You had a supervisor, I forget what Uber calls them, but this woman who was sitting next to the wheel, effectively watching the car as it was driving. And it turned out that she was looking at her phone, possibly watching a YouTube video at the time that the accident happened. And she was charged with negligent homicide. So that's looking at this as a harm, right? That's ex post liability for something that had a physical impact on one person. The risk approach zooms out, right? It says, actually, this one car is part of a complex system. And that system is Uber's responsibility to handle the risks of it. So this is an example of Uber's risk mitigation gone terribly awry. When they designed the self-driving car system, including the supervising driver, they made a decision several months before this car crash happened to increase the number of hours that were being driven, to remove the second human driver from the car, which led to significant increase in automation complacency because the human driver got bored and stopped paying attention, which is a known engineering problem. And they additionally decided to tinker with Volvo's automated braking system to make it less likely that it was going to go into effect so that they could clock in more hours of driving and fulfill Arizona's regulatory requirements and get more cars on the road sooner. So through the lens of risk, this is systemic, right? And the responsibility doesn't fall with the poor person in the car that causes the crash and kills the other person, the responsibility falls with the producer and user of the algorithm, or Uber. So with this in mind, and the arguments that Stephen gave, risk regulation has been emerging as the dominant regulatory approach to artificial intelligence. There are plenty of good reasons for this, right? Ex post liability faces access to justice problems. It faces huge issues in terms of access to expertise, and technological expertise is expensive. It can be very hard to trace causation. And when you're talking about, say, privacy harms or dignitary harms, as opposed to physical harms like a car crash, we don't really have a legal system that's set up to capture those harms ex post. Plus, there's the benefit of, if you have an AI system that's going to have an impact on so many people, putting in place ex ante risk mitigation is more likely to prevent widespread harms than an ex post system, which only deals with things after the fact and doesn't have sort of this preventive precautionary element to it. However, the type of risk regulation that is emerging here is very specific. It's focused on impact assessments, and it's focused on risk mitigation. Those impact assessments and risk mitigation, as we'll see in the rest of the talk, vary a great deal in style. But the core of it is to zoom in only on the part of risk regulation that does assessment and mitigation. And in contrast with that, it omits liability. It omits largely individual rights, which I'm hoping will get discussed later in discussions of the White House proposed AI Bill of Rights. And it largely omits public transparency and stakeholder accountability to the people who are most likely to be harmed by the use of AI systems. So I'll walk through a few examples of this, and then again, for purposes of time management, just cut it short. So example number one is the AI risk management framework that Congress directed NIST to put together. I think we're on draft 2 of that, and it should be expected to be finished sometime later this year. This is quintessentially enterprise risk management. So then this is publicly available for your perusal. So what NIST is doing is transplanting through a multi-stakeholder process its risk management approach to cybersecurity into a risk management approach to artificial intelligence. It's not top-down law, it's soft law. It's a multi-stakeholder process, and it's intended to be iterative, so the risk management framework will change over time. NIST effectively offers a blueprint for mapping, measuring, and managing risks related to the AI system. And unlike the Canadian impact assessment process, which I'm glad Stephen mentioned, this is not a one-time document. So the Canadian process and the NEPA environmental impact statement process basically envisions impact assessments as being something that you do before you use the system. The NIST process, by contrast, says you're going to do this over and over and over again. It's a cycle, right? So you map it, you do it, you measure what performance is like, and then you start all over again. And there's a lot of positive things to be said about using that iterative approach. Also, purportedly, what the GDPR is trying to do in the EU. But then here's the crux of the problem. When NIST defines risk, it defines it in a way that sounds quantitative. So it says that risk is a function, it's an actual equation, of the magnitude of adverse impact that could arise. So you're supposed to say, what's the worst case scenario? What's the bad thing that could happen? And then multiply that by the likelihood that the bad thing is going to arise. The problem with this quantified approach is that most of the risks that we're trying to mitigate when we regulate AI are not quantifiable, right? We're talking about risks to privacy. We're talking, which notoriously in our standing law, the courts claim they can't quantify. We're talking about risk of bias. We're talking about risk of discrimination. These are things that not only can't necessarily be measured through numbers, but they also, if you try to measure them through numbers, key harms get left out, right? They're likely to be left out of a quantitative approach. So again, here's the cycle coming from this most recent draft. You map your risk, you measure your risk, you manage your risk, and it's all embedded in this culture of risk management, which includes potentially a data protection officer, empowered independent authorities, third-party audits, et cetera. And all of that sounds very nice and would work really well in the cybersecurity context, where you can say, here's the likelihood that we're going to have a data breach, right? So turning to the draft EU AI Act, we see a slightly different form of risk regulation, actually a very different form of risk regulation. In contrast to NIST's approach, this is top-down law. This is centralized top-down law. I include the mostly because there are places where there's softer law or more collaborative governance, which I'll get to in just a second. The draft EU AI Act is modeled not after enterprise risk management, but after a particular flavor of risk regulation that came out of the UK, I think in the financial sector in the 1990s. And that is a risk regulation that allocates regulatory resources by risk. So we actually heard a bit of this in Stephen's characterization of the Canadian approach as well. So what the EU AI Act does, I'll come back to the products regulation in a second, is it divides uses of AI systems into 3 buckets and says, when we have unacceptable risk, we treat those systems one way. And that includes, for example, the use of facial recognition on public spaces by law enforcement. That's considered to be an unacceptable risk in the EU. We have high risk systems, which is most uses of AI that have significant effects. And then we have low or minimal use or minimal risk systems, which is everything else. Unacceptably risky systems, the unacceptably risky uses of AI systems are banned. So there is an actual precautionary starting point in the EU AI Act. High risk systems are regulated, and low or minimal risk systems are encouraged to self-regulate, looking at how high risk systems are regulated. And then once again, the high risk system regulation is risk regulation. It requires, in a nutshell, and this is a very small nutshell for a very big law, that basically the developers of high risk systems perform risk analysis, mitigation, and post-market monitoring. Now you'll notice, differing from the Canadian system, once again, and more similar to the NIST approach, this is iterative. So it's saying, here's a risk analysis, here's the plan for mitigation. You go out and you put your product on the market. Regulators are going to monitor it to see if something goes wrong. And they have the possibility of effectively something like a recall, right? To say, go back to the drawing board, stop using your system until you properly mitigate it. This is modeled on EU products liability law, which in order to allow the free movement of products in the European Union, basically requires companies to self-assess through a conformity assessment and say that their product is not risky. And once again, we have this problem where a format of law that was used to contemplate the likelihood that your chair was going to break or your elevator wasn't going to perform is being applied in a space where the risks are to human rights, right? The risks are to the ability to interact in public without being profiled and being manipulated. The risks to a community that's living under constant surveillance or has a different kind of relationship with technology companies. Within the EU AI Act, unlike the GDPR, there are no rights whatsoever for impacted individuals to challenge decisions or to challenge the existence of an AI and use of an AI system. And they've been criticized about that by the European Data Protection Board. And there's no input into the conformity assessment process, either for the public or for impacted stakeholders. Finally, I come to the Washington State proposed law. This was proposed several times and still hasn't passed. And this is an example of a third model of risk mitigation that comes out of environmental law. That model is a model of using risk regulation as a form of democratic oversight, and I think gels really nicely with the proposals that Stephen was giving you earlier. So this act was supposed to apply only to government algorithms, which is part of why it's so embedded with democratic accountability. And once again, it would require the agencies using algorithms to conduct an ex-ante risk assessment, which they call an algorithmic accountability report, and to include in that risk assessment a mitigation plan. It also includes, unlike these other laws, a substantive backstop, saying you start from a place where you're prohibited from using a discriminatory algorithm. And your risk assessment process is supposed to move your algorithm away from the box of being discriminatory. And most fascinating to me, this proposed model would have the public decide what is the risk, right? It would delegate to public rulemaking, to notice and comment, to a contestation between companies and stakeholders with official consultation of impacted stakeholder groups, a decision of like, what is the risk that we're trying to mitigate? What do we care about here? Rather than just letting companies decide how to quantify something that's inherently contested and unquantifiable. Okay, I'm going to skip really briefly here, so pardon me. No, actually, I do want to give this one. I'm going to do this and then skip to my suggestions. So risk regulation, as I said, is a tool that comes with known baggage. First of all, it works best on things that are quantifiable, like the quantified standard of a toxic chemical that gives you cancer. And it struggles, it's known to struggle with normative or qualitative harms, which are quintessentially what we're dealing with here. It's not structured to make injured people whole. It leaves out liability or compensation. It's not structured to provide civil recourse so that a person who's affected by an AI decision can't say, you know, how did you make this decision? Did you miscategorize me? Was your algorithm faulty? And it lacks the feedback loop of tort liability, where a mass litigation can come back and basically prompt a regulator to say, oops, this particular AI actually was more harmful than we thought it was. It also, and this is really important, lacks any form of public accountability, which can lead significantly to capture. So in closure, I want to get to my suggestions. We have 3 options for what to do here. I want to be really clear. I actually like risk regulation as an approach for a number of reasons I mentioned earlier. Ex ante mitigation of harms is really important. Trying to get at harms systemically rather than just individually, really important as well. But there are ways where AI risk regulation could be considerably better. First, we could address known problems. Second, we could incorporate more tools from the risk regulation toolkit. And third, we could look beyond risk regulation to complementary forms of regulation, such as either individual rights enforced by regulators or forms of private liability. And I think I'll leave it there, and I'm happy to go into more detail on the suggestions later.
Great, thank you very much. Are there any questions? So you mentioned I don't see any yet, so I'm going to start. So I'll give other people time to raise their hands. So you had mentioned the Washington State bill. Are there other state bills that you know of that would be helpful to look at?
Yeah, so I'm doing my best to keep track of all of them. So embedded in a number of the general data privacy laws, there are similar approaches. Colorado's Privacy Act has an impact assessment element to it and a right to opt out of profiling, which effectively is automated decision making. So with that one, I'm really proud of the fact that the proposed rules from coming out of the Colorado AG's office reflect some comments that our clinic submitted that suggest that impacted stakeholders be involved with those impact assessments. So if you're building an AI that you know is going to be used on particular communities or in particular contexts, figure out a way when you're doing your risk mitigation and assessment to involve the voices of the people who are going to feel these impacts. Another one, Colorado passed a facial recognition bill, which also includes an impact assessment process this is for government agencies only, but it also includes requirements that the users of AI be trained. And part of the impact assessment process is supposed to include envisioning how the AI is going to be used in practice, who's going to be using it, and can they meaningfully intervene in an AI decision. So those are just a few. The CCPA is also issuing regs around this. So the CPPA is issuing regs on the CPRA around this as well, just to mix all my acronyms.
Okay. Yeah, and I believe in our bill, we had allowed opting out, but it was for solely automated decisions. So I guess, and that's another thing is, you know, I've seen in some of these is including humans in the decision-making process. So do you have recommendations around that?
Yes, so that language, solely automated decision-making, is a direct import from the European Union's GDPR's Article 22, which applies only to a solely automated decision. Now, if you look at the regs interpreting that in the EU by the Working Party or the European Data Protection Board, those guidelines say solely automated includes systems where a human's just a rubber stamp. So you can interpret solely automated even coming out of that legislation and be consistent with other laws around the world to say, it's not just when an AI is being used by itself, but if you have an ineffective human, that counts too.
Okay. Great. Does anyone else have a question? Okay, David.
Thank you so much for the presentation. It's a really useful framing on how to approach this issue. In terms of the EU AI Act, you mentioned one example. Was it facial recognition that was deemed unacceptable and then therefore banned?
Yeah.
Are there other ones that you know have fallen into that category?
Yes, I'm going to get the precise language wrong, so don't take my paraphrasing as law. But there's a ban on like particularly manipulative systems. So the idea is if a system is such that it's completely removing a person's autonomy and effectively, subliminally influencing them into making decisions, that is also banned. There's been a lot of discussion of what that is and what the concrete examples are. And there's been fairly unhelpful responses from European legislators. The other thing I'll say just briefly is that the facial recognition ban is kind of woefully incomplete because it still imagines or allows for the infrastructure to be built, right? The ban is on police use of facial recognition in real time in public. But if you have private use of facial recognition in real time in public, that's not banned, right? And so once the infrastructure is built, you have the possibility of mission creep, and it's not, and there's nothing banning law enforcement from doing it retroactively, not in real time.
Gotcha. Thank you for that. And then the other thing is more of a comment than a question necessarily. The impacted stakeholder piece that you've hit on, I think is really critical here, both in terms of raising awareness, but then also having the folks that are really hurt or potentially harmed by these automated systems to have a voice in the process. And, hopefully that comes with some level of enforcement if they are harmed ultimately after the government in this case adopts the system. But any other suggestions you have on how to include impacted stakeholders would be great.
I would love to be part of a continuing conversation on that. That's a research project for me right now. I think there are useful conversations, especially in the environmental regulation space, about how to meaningfully involve impacted communities and what it means to be a community expert that would be really helpful to port into AI.
Nice. That sounds great. Thank you again.
David, thank you for those questions. And Bob Ridgway.
Thank you, Senator. Thank you, Professor. I was just going to comment that your presentation and Stephen's both have got me asking more questions than I know where to begin, honestly. But one I wanted to ask you, as you're discussing the regulation, were you looking at the regulation being primarily oriented toward the developer of this software or the user of the software? I mean, personally, I've got a preference, but that doesn't mean you found that to be practical or workable or how you would go about it. I figured either way it's going to go, there's going to be a cost, and the cost is going to either end up being imposed on the ultimate cost of the software and then dumped on the purchaser or user. But similarly, if the purchaser or user has the ultimate burden of of submitting to whatever regulation there was, they're going to have to deal with either the vendor again or a third-party contractor. I don't know. Have you given that any thought, or do you have any? Are you leaning anywhere?
Yeah, this is an excellent question. So the EU AI Act, my answer is going to be, here's what's not working. The EU AI Act is targeted at developers, right? But the harms it's trying to mitigate are from uses. So it's putting the responsibility for risk mitigation on the company that develops the algorithm, anticipating that particular uses are going to be made of it. It does not put responsibilities on the users. And I think that is a notable flaw. Because in some cases, some of the harms we're trying to mitigate can only be mitigated by the user of the algorithm and can only really be monitored by the user of the algorithm. So I would say the EU AI Act approach, while laudable in some ways, makes a mistake in not trying to also create some kind of direct accountability for the users of the system.
Well, and I'm seeing some bleed over into the issue raised that Stephen had raised about trade secrets and waivers of trade secrets and how to protect those trade secrets so that even if a developer has a single use application that he or she has put together, is probably based on some common principles that are variable and could be used in other projects. So I would think he would want to protect those from competition from other developers. Anyway, I'm still whirling that around as well, but thank you very much. It's very helpful.
Yeah, to make it a little more concrete. So I think that you're right. There is an information gap between the developers and the users, which will probably remain there. You're not going to have trade secrets waived in all of these contexts. And so some responsibility for developers is necessary because developers are closest to, they're the least cost avoider. They can actually change things without facing these info barriers. On the other hand, when we're talking about, human in the loop design, or we're talking about confidence thresholds, that's about training the user. Right? That's about making sure a user of the system is empowering people to meaningfully intervene in algorithmic decision-making when there's a mistake. And also making sure that, the police officer is using facial recognition that has a confidence threshold of 30% understands, like, maybe I shouldn't rely on this quite so much.
Good. Thank you. Thank you very much.
Thank you very much for those questions, Bob. I thought I saw Antoinette had a hand up, or did someone else have a hand up that came down?
Senator, I did, but I took it down. Margot answered it in the conversation already. Thank you.
Oh, okay, great. Thank you. Great. Well, Professor Kaminsky, thank you very much. And yeah, hopefully you will. We'd love to have you be a part of the continuing conversation as we work towards coming up with some legislation.
Thank you so much.
And also, I should thank David Stout for helping to arrange getting Professor Kaminsky and several of the other speakers to speak to us today. So next, Bertram Lee from the Future of Privacy Forum, just to talk about the ADPPA and some of the other state efforts.
Thank you. Good morning to the task force and Senator Maroney for the opportunity to speak with you all today. My name is Bertram Lee. I'm Senior Policy Counsel for Data, Decision-Making, and Artificial Intelligence with the Future of Privacy Forum. Today, I'll present to you all a brief overview of the algorithmic decision-making and AI proposals, laws, and proposed regulations with respect to the American Data Privacy and Protection Act, which I had the opportunity to testify on behalf of Future Privacy Forum, the New York AI hiring law, the DC Stop Discriminatory Algorithms Act, and the proposed changes to California's employment discrimination regulations. Starting first with the American Data Privacy and Protection Act, or ADPA. Important to keep in mind that Section 207 is both the civil rights section and the algorithmic decision-making and impact assessment section. And it would make it illegal to collect, process, or transfer covered data in a manner that discriminates or otherwise makes unavailable the equal enjoyment of goods or services on the basis of race, color, religion, national origin, sex, or disability. The bill also requires that large data holders, as defined in the bill as companies that have gross revenues over $250 million or more, and transfer the covered data of 5 million individuals or devices and the sensitive data of more than 200,000 individuals, must do impact assessments for algorithms that may cause potential harm to an individual, and if the algorithm in whole or in part is used to transfer or collect covered data. The impact assessment must include a detailed description of the design, process, and methodologies of the algorithm, a statement of the purpose, proposed uses, and foreseeable capabilities outside of the articulated purpose use of the algorithm, a detailed description of the data used by the algorithm, including the specific categories of data that will be processed as an input, and any data used to train the model that the algorithm relies on, a description of the outputs produced by the algorithm, an assessment of the necessity and proportionality of the algorithm in relation to its stated purpose, including reasons for the superiority of an algorithm over non-automated decision-making methods, and a detailed description of steps that the large data holder is taken or will take to mitigate potential harms to individuals, including potential harms related to any individual under 17, making or facilitating advertising for or determining access to or restrictions on the use of housing, education, employment, healthcare, insurance, or credit opportunities, and the determining access to or restrictions on the use of any place of public accommodation, particularly as related to harms related to the protected characteristics of individuals, including race, color, religion, national origin, sex, disability, or disparate impact on the basis of an individual's race, color, religion, national origin, sex, or disability status. There's also an algorithm design evaluation context of the bill. The bill requires that a covered entity, defined as any entity or person that would be covered by the FTC Act, including common carriers and nonprofits, that develop an algorithm solely or in part to collect or process covered data or publicly available information, shall, prior to deploying the algorithm in interstate commerce, evaluate the design, structure, and inputs of the algorithm, including any training data used to develop the algorithm to reduce the risk of any potential harms identified previously in the impact assessment portion. Additionally, to the extent possible, a covered entity and a service provider shall utilize an external independent auditor or researcher to conduct an impact assessment. They must submit the impact assessment to the FTC, Congress upon request, and make a summary available in a place that is easily accessible. Covered entities must also submit impact assessments and design evaluations unredacted to the Commission, but may redact and segregate any trade secrets from public disclosure. The FTC would have rulemaking authority over this section to help with compliance, and there would be reporting requirements with the Department of Commerce to see how this portion would affect commerce generally and affect the economy. For the New York AI law, the New York City Council in December of 2021 passed a bill that regulates employers' use of automated technologies in hiring. The bill was returned without Mayor de Blasio's signature, came into law, and takes into effect January 1st of 2023. The law covers candidates and employees residing in New York City. The bill would make it unlawful for an employer or an employment agency to use automated decision tool to screen a candidate for an employment decision unless the automated decision-making tool has been audited and a summary of such audit is made available on the employer's or the employment agency's website. The audit must include data required by EEO-1 filings, race, ethnicity, titles, and done by an independent and must be done by an independent auditor and have been conducted no more than 1 year prior to the use of the automated decision tool. Any employer or employment agency that uses an automated decision-making tool to screen an employee or candidate for an employment decision must notify each employee or candidate that such tool has been used. The employer or employment agency must tell candidates that an automated decision-making tool will be used in connection with the evaluation of the employee or candidate, notify the employee or candidate within 10 business days before the automated decision-making tool is used, and allow the candidate to request an alternative selection process or accommodation. Notify the candidate or employee of the job qualifications and characteristics of that automated decision-making tool will use no less than 10 days prior to use. And if not disclosed on the employer or employment agency's website, information about the type of data collected and the employer or employment agency's data retention policy upon written request within 30 days. Moving on to California's AI and hiring regulation. California is considering adding a number of changes to its employment regulations to include algorithmic decision-making systems. This bill would make it illegal to use automated decision systems in a way that discriminates based on one's national origin or ancestry, accent, English proficiency, immigration status, sex, pregnancy or perceived pregnancy status, religion, race, or disability status. The regulation states that use and reliance upon automated decision-making systems that limit or screen out or tend to limit and screen out applicants based on protected characteristics may constitute unlawful disparate treatment or disparate impact. The California also defines automated decision-making system as a computational process, including one derived from machine learning, statistics, or other data processes, or artificial intelligence techniques that screens, evaluates, categorizes, recommends, or otherwise makes a decision or facilitates human decision-making that impacts employees or applicants. And under this regulation, an automated decision-making system includes, but is not limited to, 1, algorithms that screen resumes for particular terms or patterns. 2, algorithms that employ face or voice recognition to analyze facial expressions, word choices, and voices. 3, algorithms that employ gamified testing, including questions, puzzles, or other challenges that used to make predictive assessments about employee or applicant or to measure characteristics, including but not limited to dexterity, reaction time, or other physical or mental abilities or characteristics. 4, algorithms that employ online tests meant to measure personality traits, aptitude, cognitive abilities, and or cultural fit. Interestingly enough, though, California is also changing a number of definitions as well. One of note is the change to the definition of what constitutes an employment agency to any person undertaking for compensation to identify, screen, or procure job applicants, employees, or opportunities to work. Employment agency includes, but not limited to, any person that provides automated decision-making systems or services involving the administration or the use of systems on the employee's behalf. Additionally, the regulation would make it illegal to discriminate in pre-employment access, interviews, applications, and recruitment on the basis of a protected status. Would require records be preserved, including all applications, personnel, membership or employment referral records or files, and all machine learning data, including any person who engages in the advertisement, sale, provision, or use of a selection tool, including but not limited to an automated decision-making system to an employer or a covered entity that and maintain those records of the automated decision-making system for at least 4 years. Lastly, feels like forever, the Stop Discriminatory Algorithms Act. The Stop Discriminatory Algorithms Act, or SDAA, would make it unlawful to make an algorithmic eligibility determination or an algorithmic informational availability determination on the basis of protected class status that segregates, discriminates against, or otherwise makes important life opportunities unavailable to an individual or class of individuals. The only exception is the prohibition to the algorithmic eligibility determination or algorithmic information availability determination is utilized as a part of an affirmative action plan adopted by DC or federal law. Companies are also required to submit to the DC Office of the Attorney General yearly audits of their algorithms, as well as disclosures to consumers about the uses of algorithms in these determination processes. The SDAA also requires that the covered entities who use service providers to perform algorithmic eligibility determinations or algorithmic information availability determinations must require a written agreement that the service provider is in compliance with the SDAA. If a covered entity makes an adverse decision based on algorithmic determination, the covered entity must provide: 1, the covered entity's name, address, email address, and telephone number; 2, the factors the determination was dependent on; and 3, an explanation that the individual may A, access any personal information described pertaining to that individual and that the covered entity used to make the determination; B, submit corrections to that information; and C, if the individual submits corrections, request that the covered entity conduct a reasoned reevaluation of the relevant algorithmic eligibility determination conducted by a human based on the corrected data. The SDAA would be enforced by the DC Attorney General and by private right of action, and a covered entity may be fined up to $10,000 per violation, and an individual may recover up to $10,000 per violation, as well as injunctive relief. In sum, the federal government and other states are moving forward with legislation and regulation of algorithmic systems and machine learning and automated decision-making systems. A few things that we at FPF have been thinking about with respect to these regulatory approaches. There is an inherent tension between data minimization and disparate impact with respect to protected characteristics that are hard to quantify, such as disability, sexual orientation, or even religion. That's just a reality. 2, there is currently no agreed upon third-party audit process. There is little clarity in that space, and also in certain circumstances can pose serious data security risks when done incorrectly. 3, there needs to be more clarity with respect to better definitions with respect to which algorithmic systems are high risk and which are not, allowing that definition to be broad enough to encompass harms in particular marginalized communities, but also narrow enough not to over-include systems that we all enjoy that make our lives easier. It's critical for better compliance and consumer clarity. Lastly, asking companies to check their AI for bias and harm should be standard practice, standard legal practice. AI is creating a scaling issue that civil rights laws, in particular, could not anticipate and impact communities in ways that these laws and broadly consumer protections in general could not imagine. I look forward to your questions, and we look forward to working with you on this process moving forward. Thank you.
Great. Thank you very much. Now, do you have a presentation or something that we can share out after the meeting is over, a written summary of everything you went through, or?
So we can develop one. Sorry, this is more of oral testimony.
It's more your personal. Okay.
I don't know if folks want my bullet points, but we'd be more than happy to consolidate that for you all.
Yeah, thank you. I think that would be fantastic if you were able to do that. I thank you for pointing out some of the things I've been thinking about as you go through this. Is that conflict between our data privacy law? We're trying to minimize the data, yet looking at some of the different bills in regards to AI, we're requiring record keeping for 4 or 5 years afterwards. So in some ways, there does seem to be that conflict, as well as I think the importance of the definitions, right, around what's high risk and not, and defining what should be in these impact assessments and the audit process. So these are all things we need to look at, and thank you for pointing those out. So just to clarify, for myself, I believe that the California and New York bills apply to private companies and not to government hiring. Is that correct?
The California regulation, I think, from my understanding, would apply to all employment actions within the state. It's
Okay.
general civil rights protections. I'm not as sure with New York, but insofar as the government is using private actors to engage in employment action, that might be implicated as well. We can get back to you with more specifics on that if you would like.
Okay. Yeah, no, I'm just wondering like how it works in terms of if you're a small business and you're using Indeed for hiring, right? Are there any algorithms in their initial sorts, and how would those disclosure rules, would that be the burden on the provider, right, Indeed or another, versus on if you're a business of only, a small business, 5 to 10 people, and you're hiring for one new position?
So that's a great question, Senator, and one that I think we are thinking through at Future Privacy Forum. In a number of contexts, we can follow up with you all on that with more specifics. But one thing to keep in mind, and one thing that I've always thought about. So previously, I was policy counsel at House Education and Labor Committee, and covering these technology issues. And one of the things that we thought about, and we were at least discussing at the time, I don't know if that's changed. It was a while ago, but one of the things that I've been considering is that the ultimate decision, hiring decision, is made by the employer, right? But how those employment tools are used, and the context as to how candidates are supplied is by third parties. And so there is an inherent tension there, whether those tools have been tested, how those tools have been tested, how businesses who are overly reliant on those tools can possibly get into trouble. But ultimately, hiring decisions are made by the hirer. The Indeed does not have any control over who that small business decides to employ, and the processes they're in. And so that's really where where I think a lot of discrimination occurs in the hiring and the choosing. And that's ultimately on the employer themselves, because there's no one else who can control that portion of the process insofar as discrimination occurs.
Okay, great. Thank you. Are there any further questions? And I guess this is something that I'll probably need to reach out to you, and I should have asked the others, but more along the lines of enforcement. It's something as we go through, I need to think of who, in our data privacy, we do have the data privacy unit within the attorney generals, and they're solely responsible for enforcement. But on these issues where they are, I don't know if it would solely be the attorney general, or if it would also be the human rights organization, since these are affecting, I guess in the way we're defining with the discrimination and protected classes, that would that draw in the CHRO as well? But I'm more thinking out loud, so I apologize. I'm an elected official. I should know better than to think out loud. So I apologize for that. So thank you again for your presentation. And again, I hope to keep you on standby for as we move forward with the legislation. So next, we have Evie, and I apologize. I'm going to butcher your last name, Fuel, the Director of Global Privacy from Credo AI, to talk about responsible AI governance.
Thank you so much, Senator Maroney. And it's not how it looks, so you're not the first. I'm joined by my colleague, Eric Aldana, and I think we have some slides to present. So I think Eric is going to drive on those, make sure we can get those up for everyone. So many thanks, Senator Maroney, for hosting us, for inviting us to this working group. And thank you to Representative Gilchrist and Representative Parker for inviting us here today. My name is Avi Felly, and I'm the Global Policy Director at Credo AI. And as I mentioned, I'm joined by my colleague, Eric Aldana, who is our Tech Policy Manager. So Credo AI is a private company that was founded 2 years ago, and we are a rapidly growing startup. We were excited to close our Series A funding round earlier this year, and we're proud to be a venture-backed company. Our team includes machine learning and risk experts with experience at companies like Google, Microsoft, IBM, and more. And our CEO, Navrina Singh, also sits on the National AI Advisory Committee, which is tasked with advising the President and the National AI Initiative Office. With this expertise, our focus has been building a software platform that sits on top of our customers' MLOps infrastructure and helps align both their data sets and their AI models with responsible AI governance, including practices, guidelines, industry standards, legislation, and frameworks. Our driving mission at Credo AI is to provide software governance tools that empower organizations to create AI with the highest ethical standards so that they can deliver responsible AI at scale. So we've heard already today from experts in the regulatory and policymaking space about regulation. And what we wanted to present to this group today as food for thought and to further continue the conversation is not just a description of proposed or existing policy, but really how this can be operationalized and how it has been operationalized for companies that are currently using and deploying AI. This is an ongoing body of research. I do want to note that from the start, but we've outlined 6 core tenets for how we define responsible AI. So since we use that phrase a lot, I thought it was important to just level set at the beginning of what we mean by responsible AI, which Eric will go into more detail later, but I want to outline these principles of fairness, transparency, privacy, performance, security, and sustainability. So how does it work? How does Credo AI work? I think as everyone's already noted, AI is being developed and deployed right now. It's already very much a part of our daily lives. So this slide illustrates our process with our customers that use AI systems and models. And I want to note that we fully agree with the comments that Margot and Stephen and Bert have made already. I think it's very encouraging to hear. We agree that we need more transparency in this space, and we need more ways to illuminate the black box. So we fully support the idea that reporting documentation that is regular, specific, and transparent can help to address AI risks. Scale is really what's driving the need for tools in this space. So the more tools that can automate the reporting process, the more scalable compliance will be for companies using AI to advance their business models. As we noted already in the previous slide, I think it's important to reiterate that AI is highly context specific, and where and how it's being deployed changes how it should be governed. This is particularly evident, I think, with the EU AI Act, which takes a tiered risk-based approach, which Margot has already outlined. So I'm lucky I get to go over those slides a bit quicker since she's given such a great description already. But I think these use cases that we've outlined here illustrate the different ways in which AI is already being deployed and used, and they're relevant on just discussions on how those use cases should be governed. So we're going to do a quick deep dive into the EU AI Act to provide an example of how we operationalize the governance requirements in practice. And then Eric will explain in greater detail how our platform works for any regulation, and we'll give some examples that were also referenced in some of the other presentations with this focus on reporting documentation. So the EU AI Act, or AIA, I'm going to skip over this since we've had a great overview already, but it's essentially 2 documents, the proposal for regulation and the series of annexes that include clarifications and examples. It is a regulation with capital R, so that's notable because it has binding legal force throughout every member state. And when it enters into force, it's not going to be interpreted at the member state level. There are the 4 levels of risks that have already been identified: unacceptable, which is social credit scoring systems and remote biometric identification in publicly accessible spaces for law enforcement purposes; high risk for critical infrastructure like transport, education, so using exam scoring, employment, resume screeners for hiring, financial credit scoring, law enforcement and administration of justice, things like border control, verification of travel documents, and all remote biometric facial identification systems are in that high risk category. And then limited risk is things like chatbots, and of course, minimal or no risk. So we have the main components of the EU AI Act listed here, and we could go into more detail, but I think as Margot illustrated very well, that would take certainly a longer presentation to go into all 108 pages of the regulation and the 17 pages of the annexes. So I want to move on to our focus, what we have operationalized in our platform. So what we call our EU AI Act Readiness Pack. This is again in the form of our policy packs. This is an operationalization of Article 11 in Annex 4, which is the technical documentation requirements that are required in the current draft. I think as Margot noted earlier, the pieces of the EU AI Act that will certainly require more contemplation and are still very much under discussion are the list of harmonized standards, the Declaration of Conformity, and the post-market monitoring plan. But I think that the technical documentation is a good starting point for explaining what AI is being used and for what purpose, and what explanations about its monitoring, functioning, and control are required. So I will quickly reference also just the next slide, Eric, which is specific to the input data. So the specifications outlined in Annex 4, I think are relevant to this working group as you consider data specifically used for algorithms. This should be cross-referenced with the EU Data Governance Act. So I don't want to go into too much detail here, but I would encourage this group to also examine the Governance Act. But in this presentation, we wanted to focus on the requirements on Article 11 and Annex 4. So looking at the next slide, this is basically a model of what goes into a generic policy pack for us at Credo AI. So it's the template that we would use for the EU AI Act. It's also what we would use for things like New York City's Law 144, Canada's Bill C-27, or something custom for a customer related to internal requirements and guidelines that they have developed to help themselves maintain responsible AI. So there are generic components that we put into the pack depending on what we're trying to show compliance with and what reports we want to generate. So I think it's important to note, and I think we can look at the next slide here, that there are elements for the EU AI Act that we cannot currently encode. So again, that's the defined standards and the conformity assessment piece. So I think it's crucial that the standards are developed and that they are a piece of this conversation on how to regulate and look at AI governance, is defining standards that are interoperable and global in scope, so that companies have a baseline for understanding what metrics should be used in a lot of this assessment. The main point that we focused on here is reporting documentation or artifacts, because that is what we can operationalize. And there is evidence that reporting requirements or artifacts in the form of things like impact assessments, algorithm design evaluations, algorithmic impact assessments, technical documentation, and model cards, which have all already been discussed today, are getting companies to think about responsible AI when they have not or would not previously. And in heavily regulated sectors, customers are coming to us already asking how to comply with reporting requirements. So one of the main points that we would like to make today with our presentation is that clarity for these reporting requirements is very important. And Eric is going to go into further detail on how reporting documentation works for us in practice.
Awesome. Thanks so much, AP. And yeah, I really want to highlight the piece, the reason why we're sharing so much about kind of what we built and the tools that we're building is just to highlight the need for tools to be built around these reporting requirements, right? Especially if we want to have an ecosystem where, we're not providing a lot of burden on, maybe some of the smaller companies or SMEs that are using AI. We want to make sure that we're, ensuring an innovative and competitive market in this area. But so just to talk a little bit more about reporting as responsible AI governance, I really want to dive deep into one aspect of regulation AV's been talking about, and really one generalizable policy tool, right? One of those tools in the toolbox that we believe is a key component of ensuring responsible AI governance. And that is this reporting requirement. In the AI policy and governance system, this could be things like algorithmic impact assessments, algorithmic bias audits, design evaluations, again, things we've talked about. Outside of the AI ecosystem, these can be things like nutrition labels, right? Or SOC 2 compliance reports for customer data management, or even like a restaurant sanitation score, right? Essentially, what are the artifacts that provide trustworthy information about what we might expect from a product, organization, or a system? So I want to go back to this slide that we looked at a little bit before. So we looked at these 6 tenets of what makes up responsible AI. These are the 6 qualities or characteristics that we need to evaluate to determine whether an AI product is responsible. So how do we take an AI system, evaluate it against these dimensions, and provide information, to the people who need to know it? So really, just to quickly dive into what we mean by each of these components, so it's very clear. We believe that responsible AI products are fair. So, at the most basic level, are these products that do not disproportionately advantage or disadvantage one group over another? Are they transparent, right? How easy is it for end users to understand how an AI product works? And explainability is certainly an element of this, right? Can we describe how input features of our data lead to predicted outcomes? But that's just one level. Also, there are more basic elements that exist as well, right? How good is our documentation? Do end users even know that they are interacting with an AI system? Privacy, right? Machine learning is, systems are trained on data, and whenever data is involved, especially personal data, privacy is an incredibly important concern. What information might be made accessible by using the system, and what are the privacy implications of AI products and the uses, interactions, and experiences they garner? Performance is something that was mentioned as well before. Is the AI system just behaving as intended? Safety and security, because AI systems are learning systems. They're vulnerable to a host of different kinds of attacks. So adversarial attacks are one example you might have heard, where input data is manipulated in a way that might not be obvious to a human, but radically changes the predicted outcome of the model. The really popular example here is maybe you have a stop sign with a sticker on it that makes a system not recognize it as a stop sign. And then finally, sustainability. This is that last component. So this is being looked at more and more, but what are the environmental and sustainability impacts of AI? A technology that requires significant amounts of energy and computing power to operate and is only increasing in scale. So we have these 6 tenets. Now what? There's that famous saying that what gets measured gets managed, and certainly as this is a credo for any team that is building products. And as it relates to reporting requirements, a perfect world would have very clear measurements for each of these 6 areas, but that's not the case. Certainly, as has been pointed out, there are challenges to measuring things like fairness or privacy, right? Challenges that aren't necessarily mathematical, but ethical or political. And so we want to make sure that in these reports, we have different categories of reporting requirements, things that are measurable and that might lead to constraints on behavior. So these are things like disaggregated performance that might be linked with a protected characteristic. So for example, how is the system performing for men versus women? What is the precision score of the model for different protected groups? And then also a second category of reporting requirements that are more focused on documentation of processes or decisions. So we want to make sure that reports include both of these components. So to move on quickly, because I know we are short on time, we just wanted to share. These are a couple of examples of reports that we're generating with our tools and allowing our customers to generate. So on the right, you have a report that is external in nature, right? So we had mentioned New York City's local law number 144, right, that requires companies using automated decision-making systems to perform a bias audit for fairness, and also follow certain disclosure rules to let candidates know they're using an automated decision-making system. But we wanted to make it as simple and easy as possible for a company to provide evidence and information about their systems, create a report that provides a disparate impact analysis that can be shared with with consumers, can be shared with policymakers. We're not the ones that are actually conducting the audit ourselves, but this is a kind of tool that could be used by a company to help prepare for the audits, and also a tool that could be used by an auditor. And then also reports can also be internal as well. So model cards that are generated, this is very, very common. So I just wanted to show this slide really quickly to identify, we've talked about a lot of different regulations, both enacted and proposed throughout this meeting. These are just some of them that we decided to highlight that have reporting requirements. And one of the takeaways here is that there really is no consistent standard for reporting, and reporting requirements are going to be wide across a variety of different sectors, across a variety of different risk levels, as has been mentioned. And one of the challenges that provides for a business is just how do we keep track of all of these different requirements? How do we make sure we're fulfilling these? And this is a problem that we're trying to solve by tool building. Right? Can we build software that makes evidence gathering and report generating as easy as possible? But there are also elements here for policymaking that we can look to make reporting requirements more regular, more transparent, and more specific. And so our thoughts here are the burdens of governance. The burden of governance on companies decreases the more specific reporting requirements are. And as we're looking at different reports, we found that making sure there are clear answers to these questions here are incredibly helpful for ensuring that the reporting governance is scalable and effective. So just looking here, being very clear, who is actually conducting the report? Is it a self-assessment done by our internal company team? Does it require a third-party auditor? Are the regulators the ones who are actually doing the report? Who is ultimately consuming the report? And this is really important for the type of information that is ultimately generated, right? Is it primarily technical stakeholders and non-technical stakeholders? The answer to that question is going to be incredibly important for what type of information we generate. Is it going to the public? Is it going to government officials? What are the specific report requirements? So this is kind of going back to before, are they specific measurable components, or are they documentation of processes or decisions that are made? And then finally, how does the report ultimately address risk? Like what is the purpose of this report? Is it addressing risk by promoting public accountability, right? This is going to be a report that is shown to a variety, or to the public. And so that's going to be the mechanism by which companies are going to actually, mitigate any risks that come up. Or is the report actually going to prevent behavior outright, right? If the report evaluates a particular or finds a particular behavior that the system is performing, it just it makes it clear that they're no longer able to use that system. And then finally, that last point, maybe the purpose of the report is just to identify, what are actually the table stakes, what actually are the state of the systems that are being used, to make those transparent for the public, for policymakers, and use that as a tool for generating new policy in the future. So I'll stop there. I know there's not a ton of time left, but hopefully we're able to provide some good food for thought, and happy to answer any questions.
Great. Thank you very much. So a few questions popped up in my mind, and so and there may not be answers for them now, but just one of the things when we were working on the data privacy laws, we wanted to look at interoperability, right? In having a patchwork of laws. If companies can't comply, you're not really protecting anyone, right? If you're not putting in laws that it's able for them to comply. I'm looking at the same thing with the impact assessments, right? So how do we develop requirements that aren't overly burdensome, right? And how do we put in flexibility where if you're complying with another state? And I do believe in the Washington's proposed law, they said, you could submit an assessment from another state, and if it was missing information they wanted, you could supplement it with that information. But I don't know if you guys would have any recommendations, and it doesn't have to be now. Again, hopefully you'll stay part of the conversation ongoing as to how we, and again, I think the impact assessments are probably one of the important tools, right? That we'll be looking at putting in the law. So how do we make sure that where should we look at for models in ensuring an ability for companies to comply?
I have some thoughts, and then maybe Eric wants to jump in. And thank you, Senator Maroney, for that question. I think it's very important, and certainly would love to continue the discussion with you. I don't think we can answer it in full now, but would like to take time to think about that. But one of the things that comes to mind immediately is we're often asked this question of sort of what is the best method of reporting, and I think it is important to consider context. And while interoperability is very important, that really the thresholds of acceptability are going to differ based on the use case and the application of the AI. So I think something for us to continue to discuss and really important question, but context is truly very important. It's very sector specific and use case driven.
Yeah, thank you. It's a very good point. So the other thing is you talked about, do end users even know that they're being subject, I guess, or that AI is being used to help render the decision or render a decision. Any recommendations you have, I guess, on the disclosure? And that's one of the things I found interesting in the DC bill is, it has to be no more than a page. Of course, it doesn't define what a page is. And when you're online, one page can be much longer than a typed page of 250 words. But still, I have found that interesting in looking at some of the other state privacy laws, that some of them had limited lengths. They hadn't been enacted in some of the proposed laws. So are there recommendations or best practices for the requirement of, again, looking at that transparency for how best to disclose to someone that, their decision may be rendered, using AI?
I have a thought. I don't know, Eric, I don't want to preempt you. So I think it's a good question, Senator Maroney. I think, again, here thinking about who is the consumer of the report and what's the harm that's trying to be addressed is really relevant. I'm very interested to see the blueprint for the Bill of Rights presentation following us, because I noticed that in the blueprint, this phrase plain language is used very often. And I think that's similar to the question you're posing of how does the user understand and what are the parameters that would be helpful. To be honest with you, I think since it's still such an evolving field of research, we couldn't definitively say, that can all be captured in one page versus 2 pages. So it's a tough question. But I think we could certainly share insights of what has been working effectively so far.
Great, thank you. Are there any further questions? Okay, thank you. Thank you very much for the presentation. Okay, and next, Professor Suresh, and again, I apologize, I'm most likely going to butcher your last name, but Suresh Venkatasubramanian.
So Senator Maroney, this is David. He had sent me a message that he was only able to stay on until 12:30, unfortunately.
Okay.
So I just wanted to pass that on.
Okay, great. So well, with that, we'll see maybe if we could have him come back for one of the future presentations that would be shorter. And that actually probably works out, because I told people we were going to try to keep these meetings to 2 hours, and I think that would have brought us to well over our 2 hours. So with that, I guess I would look if anyone has. Our next meeting is going to be November 30th from 11 a.m. again to 1 p.m. We are going to be looking at the children's privacy protections. And so specifically, we wanted to look at the UK Age Appropriate Design Code, the California Age Appropriate Design Code, and a few other issues. So I guess I would ask either of the my other tri-chairs, I guess, if they had any comments or. So.
Yeah, just to say thanks for everyone for sharing and for the questions, and looking forward to continuing the conversation. Thanks, James.
Thank you very much. So, well, thank you everyone for attending. And what we'll do is we'll try to, if all the presenters could send us their slide decks, we will gather that information together and Sam will be sending that out to you. So thank you everyone. And with that, I would say we're adjourned and we will see you on November 30th.
Thank you, Senator.
Thank you, Senator.
Thank you.
Thank you, Senator.
Thank you, Senator.